Well, good morning, y'all. It's about 1 after 11, according to livestock time, which means we're about 10 minutes late in the farm and ranch world. So I'm going to go ahead and kick things off. We're sitting at a roughly 55 folks on the phone, so I don't want to take up any of your time in lost time, and anybody that joins late can catch up. I want to thank you all for agreeing to jump on here and participate today and learn a little bit more about what's happened in the labor law changes and employment law changes here in Colorado in the last couple of years since the Senate Bill 87 passed in 2020. I want to thank Chad Vorthman in particular at this time. Chad is the CEO of the Colorado Farm Bureau. They have been great partners of ours and great representative of the industry. And so I want to welcome them to helping partner with us again and give Chad a couple of minutes to say hello as well.
Thanks, Zach. And just wanted to echo your comments as well. Appreciate the partnership that we have with Colorado Livestock Association and this topic that's so very important to both of our members and all of the ag producers in Colorado. Appreciate Kevin Paul taking his time to put this information together and get it out to you all. I don't want to take up any more of the time, but also just wanted to mention that I appreciate the way that we've all worked together on this key service provider issue, as well as the lawsuit. 13 ag organizations have put together almost $200,000 to fight that key service provider access, and that's due to folks like Colorado Livestock Association and their leadership, and we certainly appreciate that at the Colorado Farm Bureau. So thanks, Zach, and I'll turn it back to you, I guess.
Thank you so much, Chad. And thank you for being on with us today. I know that this is going to be just as robust and exciting a presentation as it has been in the past. We've had such great response to this, and I'm very, very happy to have this offered to you all today by Flood and Pete. They are our partners in the workers' comp space and all other things insurance, and we could not do what we do without them as well. So I want to introduce you all to Brian Schiller right quick and let him say a couple of things from Flood and Pete.
Good morning, everybody. And yes, Flood and Peterson, been partnered with Colorado Livestock Association for a number of years. We're one of the endorsed brokers in the workers' comp safety program, and we appreciate the partnership with Colorado Livestock Association and involvement in today's agricultural businesses here in Colorado, and we're here to support you. So Zach, thank you for.
Thanks so much, Brian. Thank you again for all that you do for the industry. Without further ado, I do want to point out one thing. We have worked closely between our organizations and our sister organizations, not only Colorado Farm Bureau, but Colorado Cattlemen's Association, to put together a how-to manual, essentially. Basically, we asked Kevin Paul, and he did all the legwork, but we couldn't have done it without him, and we're very proud and happy to have him as our representative and our partner in this. And Cindy Coleman has made these things possible as well, and they have put together a really robust packet of information that we've compiled here with our other organizations in partnership to make it look pretty and not just legalese. And we are going to be prepared to distribute that after this call today. And we really look forward to you all being able to utilize that as we move forward in this new world of labor and employment law. So I won't delay any longer. I know you didn't get on here to listen to me. So Kevin, I will kick it over to you. Thank you so much, sir.
You bet. It's good to be with you again, Zach. Thanks to you and Chad both for having us back today. Just my own thanks to Brian and the folks from Flood and Peterson who take good care of you on the insurance front. We're going to talk a little bit about some insurance issues today that relate to employment issues. I want you to remember that when we do these, when we get together, we're giving you general guidance, painting with kind of a broad brush. A lot of the issues that we're facing now, the individual facts really matter. And so while I can't give you legal advice in a group like this, We're going to try to give you the best answers that we can to questions that Zach and Chad have sent to us, and that you all have been calling us and emailing us with, and things that we think you'll be interested in throughout. Just do know that if some of the stuff we talk about resonates with you and you'd like to follow up with us in a private conversation, you can always get to us through either the Farm Bureau or Colorado Livestock Association, and Cindy and I will be glad to take a call from you or return an email anytime that you need. As we do, when we do these talks, I get to stand in front of you and talk at you, but the real worker here is my colleague, Cindy Coleman, who is on the chat feature this morning. That's so that we can answer your questions best we can real time. It's really hard to take questions in the middle of a talk like this virtually. And so we found it works really well for you to type your question in, and Cindy will get to as many of them as she can. If she's getting the same question over and over again, Cindy will just butt in and ask me to answer it, and we'll get to that for you. We're also going to be putting into the chat a link to a shared folder that Cindy's put together with some helpful guidance documents, stuff from our friends at the Department of Labor and Employment, and some other just pieces of guidance we thought you would find helpful. At some point while we're together today, go ahead and open that link up, get into the shared folder, and take a look and pull down any of the documents that you want. If you don't get around to doing that before we're finished today, don't worry about it. The folks at the association and at Farm Bureau will be glad to get it to you, and we can also send that link to you again after we're done today. So we're going to talk about several issues. The top ones are wages and hours. We've got new regulations that really do alter the landscape for agricultural employers in ways that you've not had to deal with before. And we want to make sure that you understand what the rules are and that you know how to comply with them. We're going to talk about working conditions regulations that have now gone in place, as Zach was saying, owing to Senate Bill 2187, that has quite a few rules and regulations that are new and are specific to agriculture that we want to make sure you understand. We'll take just a quick turn and make sure that you're aware that there are going to be some rules changes to the H2A program. We know that, especially with Livestock Association, but with both organizations, there are folks who do participate in H2A. We won't get too much in the weeds there. I just want to make sure you know a couple of things that are coming. Same with the I-9 program. The folks at USCIS and ICE have announced that they're going to reformat the I-9 coming up. So we want to just make sure that you're still doing that right. We're going to talk a lot about paid leave. Colorado is in front in many ways in establishing paid leave programs, plural now. And we're going to talk about both Healthy Families and Workplaces Act and the new family program that's coming down the pike, so that you know both what you need to do and when you need to do it. And finally, we'll talk a little bit about labor organizing. You've never had to worry with that in the past, but because of Senate Bill 87, you are now subject as agricultural employers to the Colorado Labor Peace Act, not to the National Labor Relations Act that most union organizing in the country takes place under, but in our own state version of that act. That used to exclude agricultural employers, and it doesn't anymore. And we need to make sure you know what to do if you see things that look like union organizing materials on your farm or your ranch. So we'll start here. This is what it used to be. The labor and employment law of agriculture used to be the exception was the rule. You were exempt from most of the wage and hour in particular and record keeping type of requirements that apply to other employers outside of agriculture. And you still are on the federal side, but the state has stepped in now, as states are around the country. We're not alone in this, and has introduced its own regulations that do apply to agricultural employers. We want to make sure that you're aware of what Senate Bill 87 creates in terms of its requirements. Now, we know, all of us who worked on Senate Bill 87, that it was written by people who tend to think that food shows up magically at the grocery store and don't really understand anything about agriculture and agricultural production. The labor and employment law tends to be built around the idea that people work in spaces like this, like an office where I work, not in places like where your office is, out here or over here, maybe working with sheep, maybe driving Bruce Halbert's truck. it's unfortunate because, as I always tell you when I get started talking, I'm not a farm kid. I did not grow up around agriculture. I came to this late through my work with dairy. And frankly, I find the work that you do to be fascinating. I never, ever interact with any of you that I don't learn something from you. And I take that to heart. Unfortunately, the folks who wrote Senate Bill 87 had no interest in learning anything about agriculture. They had their mind made up. They were going to impose all of these requirements, and they really weren't interested in trying to make them work for you based on what you really do instead of what they think you do. And unfortunately, what I got to tell you is get over it. This is here. It's here, it's now, and you have compliance obligations that are not going to go away. None of the states that have moved to put in place their own minimum wage, their own overtime requirements, their own other types of labor regulations that we always used to see at the federal level, but that now exist at the state, none of them have dialed those back. It doesn't matter whether it's Republicans or Democrats or independents that's running things. This is the direction that labor and employment law is going. And I really want you to take it for real that we're not going to be able to turn back the clock on this. And I want to help you best I can, Cindy and I both do, to know how to deal with this so that you don't have to worry about getting in trouble and having to call us up to get you out of it. One of the things I wanted to tell you was a little story. Cindy and I every year go to a great big convention that's hosted by the American Bar Association. That's our trade association for lawyers. And this is specifically about labor and employment law that we go to every fall. And there's a couple thousand of us that get together. And this was the very first year that Cindy and I went. And it's basically a series of workshops, kind of like what we're doing right now, where some folks from different parts of labor and employment law will get together and talk and teach all of us who are attending. This was the very first year back in November when we went, that when we went to the various sections, the various workshops, somebody raised employment law in agriculture at almost every one, and we'd never heard that before. There were advocacy organizations there, like the organization called Farm Worker Justice, and there's another organization that we're familiar with here in Colorado called Towards Justice, and they were actually part of the speakers groups in talking about how employment law, how labor law, how anti-discrimination law is moving toward including agricultural employers in meaningful ways. So I want you, I know it feels like you're the ones that have been targeted for this because of the politics in Colorado right now. It is absolutely true that you're a testing ground. Colorado is because it was easy for folks to get a bill through. They knew they wouldn't have to fight very hard to do that, but it's also going on all around the country. Here in Colorado, many of you have dealt with Colorado Legal Services. They're certainly part of that advocacy group that is looking to advance their interests through both statutes and regulations that sweep in agricultural employers in ways that you never have been before. So bottom line is you're on the radar screen and you need to take that seriously because we are now seeing claims made, Cindy and I are now seeing claims asserted and charges made against agricultural employers that we had never seen before. We've been working together for almost 17 years. It's just the world's changed and we need to change with it. So what are we going to do about this? We're going to work on establishing within agriculture what we call a culture of compliance, a culture of compliance. It has three parts to it. First of all, in order to build a compliance program, you have to know what the rules are. And that's why I'm talking to you today. And why I'll keep talking to you as long as you'll have me back. You've got to pay attention to this stuff now, to the things that your associations send out about changes in statutes. We're going to see a couple of employment law changes, most likely coming through the legislature this session that you'll want to know about and you need to keep up with. So keep coming to sessions like this. Keep reading stuff in the newspaper, in the business journal, whatever it is you take every week or every month, and keep up with it because you do need to know what it is you have to do. Second, you got to comply with it. It's just not okay to put your head in the sand and say, I don't want to do this, so I'm not gonna. The bottom line is it gets expensive. It can get really expensive. And I know there are folks on the call this morning that we've worked with that have found that out the hard way. We hate it, absolutely hate it when we have to take you guys on as a client and explain to you that because you've gotten into this, we're not going to be able to get you out without you writing a pretty substantial check. So please take what we're telling you seriously. And as Zach was saying, the association has worked with our office to try to create some compliance materials for you in plain English. We've written them in question and answer style so that it's easy to understand what you have to do and how you can actually make it work. I know it wasn't written with your kind of business in mind, but there are ways that we can make this work if we work together. And finally, remember, you have to be able to prove that you got it right. And that means writing it down. In my world, it's just magic. If something's written down, it happened, even if it didn't most times. And if it's not written down, we have a much harder time being able to establish that you not only knew what to do, but you did it right. So when we talk to you today about the record keeping that you have to do and writing these things down and making sure that you hang on to the records long enough, please take that seriously. It's not just to create another obligation for you to have to satisfy. It's really the only tool that we have if you come to us or if you go to another lawyer to help you when someone is accusing you of not knowing the rules and not doing the right thing. All right, we're going to start with wages and hours. That's an area that Colorado law has really changed. It's not the same as it used to be. And it used to be that, and it still is, that you're exempt from most of the wage and hour laws that apply under federal law, but not Colorado law. First of all, you know that now you're subject to Colorado minimum wage. That's not too tough to get your head around. In 2023, the minimum wage is $13.65 an hour. That number is going to go up every year by the Consumer Price Index. So it took a pretty good jump this year and probably will next year because even though inflation's getting under control, it's been pretty high. So at this point, $13.65 an hour is the minimum that you can pay to your employees and be compliant with Colorado state law. One of the questions that Zach wanted me to make sure I got to is about credits. Credits you can take for the lodging, for one, that you provide to your employees. If you provide housing to your employees, there is now a rule that says how much credit you can apply toward that $13.65 an hour. If you provide for your employees something like a dormitory, a single room, you can take as much as $25 a week and credit that for the lodging that you provide to the employee's minimum wage. All right, $25 a week. Not any more than that. That's the maximum you can use. If you provide the employee a full apartment with multiple bedrooms or a house, then you can take as much as $100 a week. $100 a week. That's the maximum you can take as the housing credit against the minimum wage. Remember that you have to put this in writing and the employee has to agree to it. If you're going to take that lodging credit, the employee has to know that they're going to see on their paycheck stub a credit of either up to $25 or up to $100, depending on how big the housing is you provide, and they've agreed to it. Now, we always tell folks that we think it's the best practice if you provide housing to your employees, that you actually enter into a lease with them that tells them what are the terms and conditions under which you're providing that housing to them. Because as you probably well know, sometimes you have to let people go or they decide to be on their way and they don't really realize that they're going to have to leave the apartment you've provided for them in town when they don't work for you anymore. So we like to see that in writing, because then if you need our help in making sure that the person does leave, it's much easier for us to do that. So at the very least, if you're going to use the lodging credit, make sure you put it in writing.
Kevin, let me interrupt for a second. I just want to clarify these Colorado rules regarding lodging and credits. Do they apply to H-2A workers as well?
No, they don't. H-2A is its own animal. So always remember that because H-2A is a federal state joint program, the federal regulations trump state law unless in the regulations they say they don't. And with respect to housing, H-2A's got its own requirements. Does that get it, Cindy?
Yes, what if the housing, no, that's good. That's enough.
Okay, we can always come back to it, not a problem. On meals, the rule just says that you can credit the reasonable cost or the fair market value, basically what it costs you with no markup to provide meals to your employees if you do that. Like if you have a lunchroom or something, if you're one of our larger agricultural producers, and some folks do, then they can use what would be a reasonable per meal amount, as long as the employee is making use of it, as a credit toward their minimum wage obligations. All right, question comes up. Well, we pay all our folks a salary. Every week they get the same amount, let's say $1,000. Or sometimes, this is particularly common in dairy, we pay by the shift. So however many shifts the person works during the week, that's how much they get paid. Can we still do that? The answer is yes, it's yes, but you have to be able to demonstrate that the gross pay that they get on a weekly basis, when divided by the hours they worked for that week up to the overtime threshold, and just set that aside for a second, because we're going to talk about overtime in a minute, but that number has to hit $13.65 or more, all right? So if you're paying a salary that when you put into that, when you divide their gross pay by the number of hours they worked up to 60 in the work week, that's the overtime threshold, and it comes out less than $13.65, then you're not in compliance and you're going to have to raise the amount that you're paying. But you still can, as long as you meet that test, you still can continue to use your salary basis for paying people, or you can use a shift fee as long as it meets this test and they come out to actually making at least Colorado minimum wage of $13.65 an hour. Okay, record keeping. This is really important. You didn't have these kinds of rules before, but you need to comply with them. The first thing is you actually need to have for each employee throughout the time they're working for you, the name, address, and job title. That's normal stuff, but you're also supposed to maintain a record of the date of hire. And, oh, that guy's been here forever is not a record of the date of hire. We actually dealt with a case where this came up and where we needed to be able to prove how long somebody had been employed on the particular farm or ranch that we were working for. And the owners did not keep that record, and it made our job more difficult. So make sure, if you don't have this information, you can go home today or this weekend and put it in place. You're not going to get in trouble for not having it right now, but now that you know you got to do it, you need to comply with this. So make sure you keep that record. You must keep a record of the hours that each employee works each day. You must keep a record of the hours that each employee works each and every day that they're working. And they better be accurate. Don't have records that just say 9 to 6, 9 to 6, 9 to 6, 9 to 6. Very, very few people work exactly the same number of hours, starting at exactly the same time every day, day in and day out. And the Department of Labor and Employment will presume that those records are not accurate if they don't reflect the time that the person actually started their work and actually finished their work. And as we'll talk about, there's also now meal breaks that are going to have to be part of your record keeping. So you don't have to keep a conventional time clock if you don't want to, but it's sure not a bad idea. And there are lots of electronic ways to do this now. Some of the farms and ranches that we've talked to use applications, so employees can check in, they can clock in on their phone, and that information through the app goes directly into your payroll electronic system. All you have to do is use Google and put in hours, records, and applications, digital applications, something like that, and you'll get a whole bunch of different products to look at and see whether one of them might work for you. You don't have to do it that way. You can keep the records on paper, Just make sure that they're accurate. And one of the best things you can do is to make sure, if you're keeping paper records, that the employee signs off every week on their time card. One of the things that we see quite often from folks is the claim from an employee that that's not really the number of hours that they worked, and that the employer somehow doctored their time card. Well, that's a lot harder for them to argue if they've signed off on it and you have, or your lead, your foreperson, whoever it is, a manager for you has signed off on it too, and you hang on to that. Under Colorado law now, you're going to have to keep these time records for 3 years from the day they're created. I would keep them as long as the employee is working with you and for 2 years after that. That's about the longest period of time that someone can come back and make a wage claim against you. All right, so hang on to those records for 2 years after people leave. Much beyond that, it's safe usually to shred them if you want to. But so we got to remember, hours per day, everybody's got to do it. That means people, you're paying a salary, you're going to have them keep hours the same way. Because how are we going to be able to tell that you're paying the minimum wage if we don't have their hours written down? They're also going to be subject to overtime if they work enough hours, and we'll talk about that in a second. So shift fee people and salaried people, they have to keep their hours just like the folks you're paying by the hour, and make sure they're accurate, whatever system you use, that they're accurate, and have folks sign off on them. Okay, you also need to provide an earnings statement. This is what we sometimes call a paycheck stub. This is going to be per pay period, and it needs to have this information that we're going to go over with you. First, it has to have the total hours worked within that pay period. Second, it has to have the pay period dates, so the person knows whether they're getting paid by the week, bi-weekly in 2-week periods, whether you're doing a 26 pay period year, which a lot of folks do, or whether you're paying monthly. In Colorado, monthly is as far out as you can go. You have to pay somebody at least as often as once a month. It has to have the gross pay that they're entitled to. So whatever the hourly rate is times the hours, or the full salary that you're paying them. And then it has to show the deductions itemized out. So the FICA taxes, the Social Security and Medicare taxes, the amount you're withholding for federal income tax, those items need to be written out and itemized. It's not enough to just say deductions, which I've seen relatively recently. That won't get it. It's got to be itemized so that the employee knows what you're taking out. And then you have to show them what their net pay is. That's the amount that you're either, that's on the check that they're going to go cash, or that you're putting direct deposit into their bank accounts. You have to have the employee's name on the pay stub so that if it gets lost, they know it's theirs. It has to have your name and address as their employer, so they know it came from you, and I know it came from you if we ever have to prove that you made these payments. And you have to provide this information to the employee in writing every pay period. You can't hold off and just give them an annual earnings statement. It has to come as often as they get paid. And like I said, the longest period of time that somebody can get paid over is monthly. It has to be either per month or shorter than that in order to comply with Colorado law. This is a new document that has come out. I know we talked about this with the Livestock Association last time we were with you. We just want to remind you of it. This is a notice that you need to provide to each and every employee as they are leaving your employment. It doesn't matter why they leave. If it's your idea or if it's their idea that they're leaving, you need to provide this one-page document to them. It has fill in the blanks for the information they will need in order to apply for unemployment insurance benefits. You cannot try to protect against having people apply for unemployment insurance by not giving them this document. You're going to get in trouble if you do that. So fill out the document. The link is in the document that Cindy is sharing with you in that share file folder. It's easy to find. You just go to the Colorado Department of Employment, Labor and Employment, and there's a drop down for unemployment, and it'll take you, if you push the button that says employer, it'll take you right to a page that gives you the document download link. So you can get to it really easy. It's just a one-page document. The thing we want you to remember that's kind of different is at the bottom, it asks why the employee is leaving. Did you discharge the employee? Did you lay the employee off? And it says reason for discharge. And it just has one line. You only have to put the simplest of reasons. If it's because they didn't show up for work 3 times in a row, you can say excessive absence. You don't need to write a book and turn the sheet over on the back and keep going about how this is the worst human being you ever employed on your farm or ranch and you don't know how you made such a big mistake. Just make a very simple statement that either the employee was not capable of doing the work, didn't show up when they were scheduled, violated your animal protection policy, whatever the reason is, just a few words. Don't write a book. Make sure that it's accurate. Make sure that it's accurate, because you're going to give this document to the employee when they leave. You're going to keep a copy of it in that employee's file where you're keeping all those payroll records we talked about. You're not going to send this document to anyone. It doesn't go to the Department of Labor and Employment. It's just for you to provide to the employee and you to keep a copy. Nobody has to sign off on it or do anything with it. It's intended to assist the employee if they are intending to apply for unemployment insurance, okay? So we're not gonna send it anywhere. Keep a copy. Okay, now if for any reason you were taking a nap, that's fine with me, but now it's time to wake up and pour yourself a cup of coffee and fasten your seatbelts, because the state has now imposed on agricultural employers their own overtime rules. You have always been exempt and still are exempt from federal overtime because you're an agricultural employer and to the extent that you hire agricultural employees. That's not the case anymore though, because of state law. And so we're going to walk through how overtime works in Colorado. First of all, it became effective November 1st, 2022. And not everybody knows that. Now, you're not going to get in trouble. The black helicopter is not going to land on the front lawn and people jump out and come get you. But if you have not been paying overtime, according to the rules that we're going to discuss right now, since November 1st of 2022, you're going to need some help because you can correct the problem. I can't give you a broad brush explanation of how we would do that because it depends on the circumstances that you operate under. But whatever you do, if you're looking at November 1st, 2022 saying, man, I didn't know I had to do that, please, you don't have to call us to help you. You can get your accountant to help you or another lawyer to help you. But just realize you do need to fix the problem. If you had people who were working overtime during that period of the year, during those last couple of months of 2022, according to the rules we're going to talk about now. For 2022 and now for all of 2023, the number you need to remember is 60. The overtime threshold is 60 hours in a work week. And you're going to have to make sure that you're getting used to the idea of measuring everything by the week, the 7-day work week. The 60-hour mark is the difference between paying people their regular rate, which is the number that has to exceed $13.65 per hour, up to 60 hours, and what we're going to start learning to call premium pay. That's the amount that they get paid for every hour or portion thereof that they work beyond 60 hours in a single work week. That's for 2022, 2023. Now we're going to talk about what happens in 2024 and 2025 just briefly, because we'll have time to talk about this later, but I want you to know what's coming. In 2024, we're going to switch from everybody being on a 60-hour threshold to small employers who have less than 4 employees, so really small farms, and less than $1 million in adjusted gross income for their tax purposes. So the little folks, they are going to have an overtime threshold of 56 hours starting in 2024. Everybody that's not little is called a large employer, and your overtime threshold drops to 54 hours, 54 hours per week, per work week. At that point in 2024, the employee is going to be entitled not to just their regular rate, but to premium pay, overtime premium pay. So just to make sure that all of this year, all of 2023, the number to remember is 60. For purposes of planning into 2024, it's either going to be 54, or if you're a smaller operation, 56 as your overtime premium pay threshold. When we get to now, there's one other rule that I want to go over really quickly because it's confusing. We could almost do a talk on this. The Department of Labor and Employment has created a category of agricultural employers called highly seasonal employers. And they've created your own special rule for 2024 and 2025. A highly seasonal employer can identify 22 work weeks out of the year. They're broken into 3 or 4 periods of at least 4 work weeks each. So the number to remember really is 22 work weeks during the year, during which you employ at least twice as many people as you do during the remaining weeks in the year. So at harvest time, you employ a whole bunch. In fact, it's at least twice the number of people you hire through the rest of the year. And they work for you at least 22 weeks, 22 work weeks for harvest or planting or whatever else you would hire them for. You get to use the 56-hour threshold for those 22 weeks. And then when your employment drops, 48 hours for the rest of the year. That's the rule for 24 and 25. And that's for highly seasonal workers. Now, there's a document in that shared file folder, if this applies to you, that should help a little bit in explaining this and kind of mapping it out, because it's confusing and it takes me a while to get to remember exactly how it works. When we get to 2024, I'm quite certain that Farm Bureau will certainly be helping folks who are in business such that they have this kind of fluctuation in their workforce so that they get some help with it. All right. Then when we
Evan,
get
I've got a math problem for you here.
okay.
If you have 6 employees, 3 are direct.
I lost you, Cindy.
Count, or only the 2 indirect and 1 hired employee for these rules?
Come back one more time. You broke up.
Oh, if you have 6 employees, 3
Right.
are directly related and 2 are indirectly related, and 1 is a hired employee, do all 6 count, or only the 2 indirect and 1 hired employee for these rules?
The 3 people who are in your immediate family, which I assume is what you mean by directly related. So mom, dad, sister, brother, uncle, aunt, wife, husband, children, grandchildren, they are carved out with respect to the overtime rule. In your example, the 3 folks who are not within that immediate family definition I just went over, and the 1 person that's no way related, they are outside of the exemption and inside the overtime rule. Okay. Now, when we get to 2025, 48 hours is going to be the overtime threshold for all agricultural employers across the board. No more distinction between large and small, no more highly seasonal. Everybody's at 48, while other employers are at 40. And because of that difference, this may all change. And we'll talk about that in a second. Also remember that we've been talking about overtime that comes because of the number of hours somebody works in the week. We also have an overtime rule for how many hours somebody works in a day or in a single shift. And that number is 12. This is the rule now. It's been the rule since November 1st, 2022, and it is across the board, the rule. If someone works more than 12 hours in a single day, a single calendar day, or like at a dairy, they work the night shift and they start at 11 at night and they get off at 7 in the morning. And normally, and they have to stay late and they work more than 12 hours, then they are going to become eligible and entitled to overtime. It gets weird because we do something different for people who work 12 hours in a day than we do for folks who work 60 hours in a week during 2023. What we got to do depends a little bit on whether it's weekly overtime that we're talking about or that 12 hours in a day or a shift overtime. Let's start with weekly. All time over 60 hours in a work week is paid at time and a half based on the individual's regular rate. That amount that they get paid over and over and over, whether it's their salary or whatever, up to 60 hours. When we do the gross pay divided by the hours up to 60, that's the regular rate we're going to work with. So we use either their hourly wage or we use our formula that we talked about with gross pay divided by the numbers of hours up to that 60 threshold. So now they're going to be entitled to overtime. And we now calculate beyond 60, the pay is the regular rate times 1.5. That's what we're calling overtime premium pay. So up to 60, it's the regular rate. After 60, it's regular rate times 1.5. So let's just run through a real simple example on the chalkboard here and make sure, doggone it, make sure that you understand while I'm dropping the clicker all over the place, how this is going to work. So we've got somebody that gets paid a salary of $1,000 per week. When we do our math and we figure out their regular rate, we take 1,000, we divide it by 60, and they're at 16.67, $16.67 per hour. That's higher than the Colorado minimum wage, so we're good to go with that regular rate. Now, we're going to talk about a week where they work more than 60 hours, So we know that they get the regular rate, $16.67 an hour for that first 60. Once we flip over into 61, 2, 3, 4, 5, then we do some math. We take 1.5, multiply it by the regular rate, $16.67 an hour, and the overtime premium pay rate is now $25 an hour. So for every hour or portion of an hour beyond 60, so 60 and a minute on out, you're going to pay $25 an hour. The first 60 though are at 16.67. It's not just because you work 60 hours, you don't get $25 an hour for all 60. Okay, keep that in mind, and we need to make sure that the paycheck that the person is getting shows this calculation, how many hours of overtime they're getting paid for, separate from how much of their regular rate they're getting paid. All right, now let's talk about the other overtime, the 12 hours per day overtime. This, we don't actually have to pay money for the first 3 hours of overtime. If they work from 12 hours to 15 hours in a single day, this has nothing to do with 60 hours in the work week. Now we're talking about a single day or shift. Between 12 and 15 hours, they're entitled to one 30-minute paid break. This is separate from the lunch breaks we're going to talk about and separate from the rest breaks we're going to talk about. This is an overtime break that hits when they work between 12 and 15 hours, single day or single shift. They are entitled to one extra 30-minute break, and it's paid, and it should come in the same week that they worked that 12 to 15 hour shift. And in fact, you can give it to them if you know that you're going to need them to work. You should give it to them during that shift, like between hour 11 and hour 12. They get that 30-minute paid break. If you don't know you need them, somebody calls out sick at the last minute, you got to keep a guy in the milking barn extra hours, and they're going to work like 14 hours for that shift. Then you can give them the 30-minute paid break the next time they work. All right. Now, if they work more than 15 hours in a single day or a single shift, and that happens sometimes, Then they're entitled to the break, the 30-minute break, because they worked from 12 to 15. And then because they worked more than 15, they're entitled to 1 hour's pay at minimum wage, $13.65 now. All right. I know it's a little complicated and a little weird, but stay with us. There are documents. There's an info sheet, it's called, from the Department of Labor and Employment in the shared file folder that Cindy has given you access to that explains this. But just remember, this is for 12 hours or more in a day. This doesn't change the fact that if at the end of the week they've worked more than 60, they're going to get overtime. They're going to get the overtime premium pay that we've talked about. All right, there is an exception that is going to apply to a lot of the folks in the Livestock Association and some of the folks in Farm Bureau that work with livestock. This depends upon two pieces. One is what we call the salary basis, and the other is the job duties test. The salary basis for a person to meet this exemption is right now in Colorado, $961.54 a week, which works out to $50,000 a year. If somebody's not being paid this much, then this exemption won't apply to them. And that number is going to go up from year to year by the Consumer Price Index. So for 2023, the number is $961.54 a week, which equals out to $50,000 a year. If they're making that much, then we look at what they do. The name of the exemption is Decision-Making Livestock Manager. And the thing to keep your eye on is Livestock Manager. They have to be full-time working with livestock. So not somebody that just every once in a while throws in, and most of the time they grow your corn or whatever. And these are folks who work directly with cows or sheep or other livestock on a daily basis, full time. That's their job. They have to have a job that requires independent judgment and discretion. This is a very common phrase in employment law. What it means is they don't just get told what to do. They have to independently make decisions that are going to be important to your ranching or farming operation about the livestock that they take care of. All right. Probably not somebody who just works in the milking barn, but possibly somebody that you identify as the shift manager for the milking barn. Then they have to do one of two things. They have to manage the work of 2 full-time or full-time equivalent employees. I don't know very many part-time employees on farms and ranches, so I'm going to just say 2 full-time employees. So again, thinking about a manager in the milking barn who's responsible, the supervisor who actually tells the other folks in the barn what to do, maybe schedules them for their shifts, is responsible for making sure the equipment is working correctly, has important jobs that are beyond just doing what they're told to do. They might fit this. If they, on an org chart, would have a couple, 3, 4 employees that they're responsible for supervising, or if they don't do that, they report directly to the owner or to the second in command, the owner's right-hand person. That's the way that somebody becomes exempt from overtime as a decision-making livestock manager. They got to make enough money, $961.54 a week for 2023, and they have to full-time work with livestock. They've got to engage in independent decision-making, manage 2 full-time employees, or report directly to you, the owner. If that's the case, and you write this down in a job description for them, so that when the government comes in to audit you, you have proof that this is what the person's job duties are, and their payroll records show that they make that salary basis test, then you don't have to pay them overtime. And instead, you pay them a salary. You don't pay them hourly, you pay them that salary that we talked about. If you blow this, it's going to cost you. Overtime, failing to pay overtime is like, it's like candy to a baby for a plaintiff's lawyer. Under our Wage Claim Act, there are big penalties that apply where employers fail to pay overtime to people who are entitled to it. You've never had to worry about this before. I'm sorry you have to worry about it now, and you have to worry about it since November 1st of last year. There are attorney's fee shifts And there's interest that piles up if you haven't paid overtime, and the state will not give you the benefit of that 60-hour threshold if they come in and determine that you have folks who are eligible and entitled to overtime who've been working more than 60 hours a week or more than 12 hours in a day or a shift, and you didn't compensate them for that in accordance with these rules. They're going to apply a 40-hour threshold. And most folks who work on farms and ranches oftentimes work more than 40 hours, and they're going to zing you for overtime at that threshold, not the 60-hour threshold. I'm just trying to make the point. I said it early on. This is a lot to get used to. It doesn't feel real good the way they did it to you, dumping all of this on you at once. I don't like that fact either, but it's here and you have to comply. And if you don't, remember that radar screen. There are folks looking to come out and demonstrate, prove that farms and ranches, orchards and greenhouses, other agricultural producers will not comply with the rules that apply to them now. They're going to be looking to hit you with this kind of stuff, and I don't want them to do it successfully. So please take this seriously and use the overtime rules and get it right. Now, as I was saying, now that we've gone through all this, it may change. There's a lawsuit pending right now in Denver District Court that challenges the division's overtime rules. It's some of the same farm worker advocacy programs that are really pushing back on us about the key service provider access provisions. They have said in their lawsuit that Director Moss of the Division of Labor Standards and Statistics within the Department of Labor and Employment did not have authority to create a special overtime rule for agriculture, that agriculture should be subject to a 40-hour threshold, just like everybody else. And they've so far managed to keep this lawsuit going over the state's defense. It's still got a ways to go. No doubt it will go up on appeal. So we may not know this for a while, but we may not get to 2025 and that 40-hour, 8-hour threshold for everybody before this lawsuit upends the rule and we have to learn something new. But for right now, everything that I went over with you is the rule. It is the law in Colorado. And I really, really hope that you will manage to comply with it. All right, now let's move to working conditions as opposed to wages and hours. As Chad mentioned, the key service provider access provisions that are included in Senate Bill 87 are the things that say you have to let somebody who identifies themselves as a service provider, and it's very broadly defined with almost no guardrails around it. You have to allow them to come onto your property to meet with employees who are on a break or otherwise aren't working unless they identify themselves as a healthcare provider. And it doesn't just say doctor or nurse, it says healthcare provider, and you must let them meet with an employee at any time, whether the employee is working or not. There are other requirements that are put in place by rule from the Division of Labor Standards and Statistics that we won't go through. There's an info sheet in the materials that Cindy has given you access to that goes through the requirements. We, through the coalition, have actually sued the Department of Labor and Employment and the division, arguing that this thing actually creates a taking of private property from each and every agricultural employer in the state, and that therefore the state owes you money. Because what happens when somebody wants to put a pipeline through your property, they have to pay you for the diminution in value of that pipeline. Well, they've now, according to our theory, put an easement across your property for service providers that you can't say no to, and they owe you compensation for that. We're in the very early stages, although I think we may get an answer here that'll help us, or at least tell us where we are with it before very long. The advocacy organizations intervened in our case. We were working very smoothly with the Attorney General's office because we took the position that we're going to be transparent. We're going to tell you exactly what we're doing and why we're doing it. The advocacy organizations got involved and things got complicated. But we're doing our best for you. And if we can't find a door, we're already thinking about a window to try to get back to the legislature to get this thing changed, because it's just flat dangerous. Somebody's going to get hurt if we can't put up more guardrails. Given the circumstances, we started talking about with both Farm Bureau and Livestock Association, as well as with dairy farmers, about folks now beginning to develop visitor protocols. If you don't already have these, and the folks that are growing fruits and vegetables almost all have protocols where people can't go because you're in the fresh fruit and vegetable business. We all need to think about having these in place, and we need to think about having stuff in writing that we hand out to every visitor. And it's important, it has to apply to everybody, including the vet who comes on once in a while because you want them there, including the guy who comes to fix the tractor when it breaks down because you want them there. The only way we can make this work is if it applies to everybody, and maybe have them either sign into a logbook, like I know the fruit and vegetable folks use, or sign some sort of document that says they got your protocols and they're going to comply with them, that tell them where they can go and where they can't and where they can meet with folks, because you have to provide a quiet, private place for them to meet with the employees that they're there to meet with. So let's show them, here's the place you go. You don't need to go roaming around the rest of the farm or the rest of the ranch. Something like this, welcome to our dairy, sign on the door, for your safety. That's what we're focused on. For their safety, these service provider people who may never have been on a farm or ranch before in their lives and wander on, and they're going to find your employees to go talk to about organizing a union. Somebody's going to get hurt. So we want to emphasize in these protocols that the main purpose of putting them in place is to protect the safety of the service providers as well as the employees. We'll talk more about this. I hope that we'll be working with the association and with Farm Bureau in trying to develop these, because from our perspective, they should be somewhat uniform. They can't be totally uniform because you work in different ways, but we want to be able to say what you've adopted is becoming the industry standard in Colorado when people come onto your property. Things like a notice at the gate that says, welcome, come directly to the office. Do not pass go, do not collect $200. Come let us know you're here for your safety. Put up signs this way to the office. So there's no way that they can be mistaken. And so when they violate your very reasonable, safety-oriented visitor protocols that apply to everybody who comes on your farm or ranch, we've got a good argument to make that they're the ones that are causing the problem, not you. If something goes wrong, if people will not comply with your reasonable directions, if they get argumentative with you, if they get physical with you, 911. Do not engage in self-help. Do not become confrontational with them. We are the ones who are going to have to manage this problem that we're faced with. And please call the sheriff's office, tell them you've got people trespassing on the property, let the sheriff's department figure it out, but don't try to remove people from the property unless they're going to spoil a truck of milk or something else like that, where the outcome is horrible if they aren't stopped. Do not, except in an extreme emergency, try to physically confront somebody. We're hearing in the stuff that the advocacy organizations that filed in the lawsuit were pursuing that, oh, this happens all the time, that they get threatened with physical violence and all this stuff. I don't believe a word of it, but I don't want to give them the reason to be able to say that it happened. All right, transportation policy. This comes out of SB 87 too, and it's important to remember that if you provide housing for folks and you provide if you provide housing for folks on your property, whether that property is the farm and ranch or whether it's in Fort Morgan, and they don't have their own transportation, you are supposed to provide them the opportunity to drive to town if they live out in the country on your property at least once a week, unless they're a range worker working out on the open range with cattle or with sheep, in which case you need to offer them a trip to town once every 3 weeks. These are for people who don't have their own transportation. They don't park their own truck on your property, and to whom you provide housing. They don't live in town on their own, okay? Once per week, You have to have a policy that tells them this. We've created a template for you that's in the chat, in the document Cindy's given you access to, that you can use to develop your own policy. You can't just use it as it is. It won't fit for everybody, but it's a good starting point. Make sure you're complying with this if it applies to you. When I'm mentioning range workers, I just want to make sure that you know that there is a proposed final rule in the H2A world that will make some changes in the requirements that you have to meet. One of them is with respect to housing. It's going to permit more inspection. Okay, I dropped off for just a second. I just wanted to say, be careful about compliance if you're in H2A. Think about developing a manual with checklists to go over so that when you look at your Form 970 or when you are ready to send a guy out with a sheep camp, you have documentation that demonstrates that you're complying with your obligations. Back to Senate Bill 87. Make sure you remember you've got new obligations with respect to heat training. There are different sets of obligations, whether it's 80 degrees or 95 degrees. There are weeding and thinning requirements. And of course, the famous hoe rule now that we have to deal with. So just make sure you know what those employee safety obligations are. They're in the chat. There's an info sheet on what you have to do in terms of training and extra breaks for people who are weeding or thinning. Let's now move to the breaks part of this. We have unpaid meal breaks and paid rest breaks to learn about. Everybody is entitled, everybody who works full-time, and that's more than 5 hours in a shift, is entitled to a mandatory 30-minute meal break every shift. If that meal break comes with no job duties, where they can go read a book, watch television, play on the computer, do whatever they want while they're eating, then it is unpaid. It's unpaid, and they need to clock out while they're on that meal break so that you have evidence that you gave them the break. Do not allow people to waive their lunch break. They have to clock out and they have to take that 30 minutes off. It's not permissible for them to waive it. In certain circumstances, you can determine, you as the employer can determine that a meal break that lasts for 30 minutes without job duties is impractical. Several people all called out, and you need this person to keep working through their meal break. They get to eat and you have to pay them. And you cannot have this happen time and time and time and time again in a week where every meal break, it's impractical to give them a job-free meal break, a duties-free meal break. Don't do that. It's for special circumstances, and it's circumstances that you decide require that they keep working through their lunch break. And what they get to do is they get to eat and they get paid while they're working. Rest breaks now. Okay, rest breaks are always paid. Not like the 30-minute job-free meal break, they get paid. Here's the chart that shows you how many rest breaks somebody gets. The most often is going to be where somebody's working from 6 to 10 hours. They get 2 rest breaks equally spread out during their shift. If they work more than 10, up to 14 hours, they get 3. In the weird situation that they work between 14 and 18 hours, which does not happen very often, they get 4. They're supposed to be spread out during their shift, usually on either side of that meal break that comes in the middle, and these are paid breaks, okay? Be very careful about people who skip breaks. An employee under the rule is permitted, if they want to skip their break. There's not much reason they would want to do that because it's a paid break. And the rule says if you coerce them or offer them anything to skip their break, like paying them extra money, like if you don't take your 3 breaks, I'll give you an extra $100. Don't do that. That will get you in trouble. And when people leave your employment because you want them to leave your employment and they're mad about it, they will come back to haunt you on this issue. It's a real easy one for a plaintiff's lawyer to say, well, they were supposed to get at least 2 and maybe 3 of these paid breaks, and they didn't get them for 6 months. That's going to rack up some money. And don't let yourself get into that bind. You can't have a policy that says you just take a break whenever you need one. You have to have a policy that follows the comps order rule, that is the rest break rule now, that says you get at least 2 10-minute breaks. They're paid breaks, and you don't have to work during those breaks. You get an extra one if you work more hours, and it's paid as well. This doesn't mean that you can't still have a rule that if somebody overheats and they need to sit down for a few minutes, or they're worn out, it's been a hard shift and they need an extra break, you can let them take that. But your policy has to be that they get the amount of rest breaks that the state requires, okay? Don't combine their mandatory rest breaks all at the end of their shift and let them go home early. You're giving them an incentive for declining to take their rest breaks, and that will get you in trouble. So don't do that. Even though I've heard lots of good reasons where the employee wants to do that, don't do it. They've got to take the breaks during their shift, and they're paid. All right, extended meal breaks. If somebody works more than 40 hours in a week, they get one 1-hour unpaid meal break either that week or the next. So instead of that 30-minute meal break, it extends out to an hour. And it's still unpaid so long as they don't have any job duties. They have to give you 24 hours notice of when they want to take it. All right. So they work for 40, let's say they work 45 hours in a week. Now remember, this isn't 60. This isn't the overtime threshold. This is 40. They work 45 hours in a week. They're going to get one extra extended meal break that is unpaid. And they get to take it during that week or the next, whenever they want to, but they got to give you notice when they're going to do it. All right. I know this is a lot of stuff. I'm trying to just get everything out. And then if we have to come back and do even another deep dive, we'll do that. I promise. Okay. Additional paid breaks. All right. So we've got meal breaks. We've got mandatory paid rest breaks. We know if you're over 40 hours in a week, then you get one of your 30-minute meal breaks extended out to an hour so that you have time to leave the farm and go do some business and come back if you have to. And now we're going to talk about additional breaks that are based on time. If somebody works more than 60, there's our overtime number for 2023, not 40, 60. More than 60, they get one additional hour of time off. So this is, they're already going to have a 30-minute meal break that extends out to an hour that's unpaid. They're already going to have their paid rest breaks each shift. Now, if they're going to, when they pass 60 hours in a work week, they get one additional hour worth of a break where they don't have to work. And if they work more than 70 in a work week, they get another additional hour worth of a break that they don't have to work. And these are paid breaks. They count as overtime hours. So you pay the break at the overtime premium pay rate. All right. We know if they're past 60, they're into overtime. If they're past 70, they're certainly into overtime. And you have to pay them for those additional hours at their overtime rate, not their regular rate. And you don't get to ask them what they're doing with their time. It's for anything that they want to do. The rule says one of the reasons is to go meet with service providers, which we argue means that service providers don't need to come onto your farm because in weeks where they're working a lot, they get extra time off and it's paid at the overtime rate. Okay, remember.
Evan, I was going to interrupt for a second.
Yeah,
I think this is a question that everyone thinks about. What about your employees who are behaving badly? The ones who just refuse to take their break and they're out in the field, so you can't really tell if they did or didn't. What do you do?
You discipline them, you give them 3 chances to get it right, and then you terminate them. And I say that because If they find their way to Colorado Legal Services and tell them, I never got a break. I worked 18 hours a day, 7 days a week, and we got no breaks. And Cindy and I have dealt with a case that made exactly those allegations. We didn't have the records to prove that the guy had taken breaks, and we had to pay. It's not worth it to keep somebody around on your crew who won't comply with your rules. Tell them what the rules are, give them a chance or two, so they're sure they know what the rules are, and then let them go if they don't comply. You can't take the risk on this because it gets expensive.
What about employees who didn't actually keep their time records despite you telling them to? Can you retroactively recreate them?
You can, as long as the employee signs off on it. If they are routinely not keeping their records, they're not clocking in, they're not clocking out, they're not doing what they're supposed to, I don't think they need to be part of your workforce because they are putting you at risk. But if somebody makes a mistake and they just didn't clock out, they forgot to or forgot to clock in, yes, you can correct a single error like that, just as long as everybody signs off on it. We'll talk about discrimination claims for just a minute because we've seen them. Two agencies, the U.S. Equal Employment Opportunity Commission and the Colorado Civil Rights Division, are together responsible for pursuing complaints that employees file against their employers. You'll see a document, you may, I hope you don't, but more and more farms and ranches are seeing them. It's called a charge of discrimination that alleges a form of discrimination, usually based on race, national origin, age, sex, or disability. If you get a document that looks like this, do not put it in the top drawer and hope it goes away, because it's not going to, and you're going to need some help in responding to it. And there are some tight deadlines that we can call up the CCRD or the EEOC and get an extension. But if it lapses and nobody called up and asked for an extension, it can get you into trouble, okay? Remember, we said we talked for a second about I-9s. Please don't forget to do them. You want an I-9 completed for every employee, everybody who works for you, and then you have to keep it for a year past termination, or a year past the termination, or 3 years past the date of hire, whichever is later. Cindy's putting a little reminder worksheet in that group of documents for you, so you remember your record keeping requirements. The I-9s you're using right now say that they expire on August 31st, 2022. That means nothing. All that means is the government hasn't gotten its stuff together and made their new I-9 forms available yet. It doesn't mean that your I-9 that you did this week is expired for some reason. The government will issue a new I-9 with a new expiration date. Don't throw the old ones away and make new ones. You don't, that doesn't apply to you. It's just a note that the government hasn't issued their new ones yet, okay? All right, workers' compensation retaliation. Shout out to Flood and Peterson for doing this for us today. Please, please, please do not take it upon yourself to investigate workers' compensation claims. If you think somebody is faking it and saying that an injury or an illness was work-related when it wasn't, call Brian or whoever your broker is and let them handle it. They'll ask you for what information you have, but do not take it upon yourself to fire somebody or otherwise discipline them because you think they're lying about a workers' comp claim. There is a claim called workers' compensation retaliation that comes with damages that have a much higher cap on them than some of the other stuff that we work on for you. And I don't want you to do that. Flood and Peterson, if they're your workers' comp carrier, they're going to take care of the problem. They'll need your help, but let them do their job. Don't do it for them. We just dealt with a case that was much more complicated because it had this built into it. Also, shout out to Flood and Peterson. Make sure you check with Brian or your broker about whether you have insurance called Employment Practices Liability Insurance. We usually refer to it as EPLI. This is insurance that protects your business if you get one of those charges of discrimination. Almost always EPLI will provide for the fees for a lawyer to represent you, and it will also help with the cost if you have to settle or if you go to court and you wind up with a judgment against you. It is really, really good to have, because when we have to help you folks out and we know that if we settle the case, the money is going to come directly out of your pocket, all of it. It is so much harder than if we have the backing of a good insurance company who's taking care of you. So please check your insurance policies, get your broker all you have to do is make a phone call and ask, and they'll be able to tell you whether you have it or not. And if you don't have it, take a look at adding it to your general insurance. Always keep this in mind. Always keep this in mind. I'm old enough to think that these things used to have a cord on them and people talk to each other. That's not all they use them for anymore. Every case I deal with now, every discrimination case I deal with now, the lawyer on the other side says, well, counsel, maybe you want to change your mind because I have a recording. It just happens. Every difficult conversation you have with an employee, particularly if you're terminating somebody, you should assume that somebody pushed the red button on the phone and is recording it. And remember, in Colorado, we're what's called a one-party consent state. It only takes one person, one part of a conversation to decide it's okay to record. And it can be the person recording. They don't have to tell you they're doing it. So choose your words carefully. If you are going to talk to an employee about disciplinary issues, or you're going to let the employee go, don't lose your temper, because dollars for donuts, I'm either going to hear it, or in the really good ones, I get to see it too. Paid leave. We got two kinds: Colorado Healthy Families and Workplaces Act leave. That's been in place since 2020. It provides two types of leave: paid sick leave and paid public health emergency leave. No exceptions. For a while, smaller employers weren't covered, but now everybody's in. Everybody who has one employee. Paid sick leave, you accrue, the employees accrue 1 hour of paid sick leave for every 30 hours that they work. All right. Everybody who's paid hourly, and most folks on farms and ranches are not going to be overtime exempt, so they're considered hourly employees, even if they get paid a salary. They're going to get 1 hour of paid sick leave for every 30 hours they work. If you do have one of those livestock managers that gets paid a salary and is exempt from overtime, you assume that that guy's working 40 hours a week, no matter how many hours he works. And he accrues a little more than 1 hour for every 40 hours that he's working, right? It's like 1.3. This is up to a maximum of 48 hours per year. You can accrue 48 hours per year. You can use 48 hours per year, not more than that. It carries over into the next year if you don't use it, but only up to 48 hours for that year. So if you don't use any sick leave and you carry over 48, you don't get an extra 48. So you got even more. That's not how it works. It's 48 hours a year that folks have access to, and it's for an illness that they have or for taking care of a family member who has an illness. One thing that some employers do in order to make this easier is they just give folks 48 hours of sick leave on January 1 and tell folks you can use it throughout the year. You have to manage it so you know you've got it when you need it, but we don't accrue it because it takes too much time, and because of this. For our purposes, for employment law, COVID ain't over yet. We still have public health emergency leave. That provides every employee who works full-time 80 hours for pandemic-related illness. So if they get COVID, they've got 80 hours within which to quarantine, to take care of themselves if they're feeling badly, to get to the point where they have 2 or 3 rapid tests and are clear of the disease and won't pass it on to others. Or if we have another situation in which COVID spikes and they close the schools and people need to stay home with their kids. 80 hours of leave. They don't have to come to you and ask if they can use it. They get to use it if they have one of the reasons for which they're entitled to use it, and you don't get to ask for any kind of documentation like a positive test or anything. If they tell you, I gotta stay home because I got COVID, they're on paid public health emergency leave. For about 2 weeks, the government added RSV and influenza to this. You may have heard a talk that we did where we talked about this. That went away and they didn't tell us about it. But Cindy was on the website today and it's like, that's not there anymore. So it's only for COVID related issues. If they're sick with it, if they think they have it, they tested positive for it, they've got a kid or a family member who has it and they have to take care of them, they have 80 weeks to use. This remains in place until 4 weeks after the public health emergency goes away. That's both the federal and state public health emergencies. The federal government has told us we'll get 60 days notice before they're going to end the public health emergencies. We think that the state will do the same, but once that public health emergency ends, people still have 4 weeks to use that COVID leave. I don't know whether people are going to be dishonest and use it even though they don't have COVID, because you don't get to ask them to prove that they have it after the public health emergency lifts. But please just know the rule and comply with the rule. It's going to be easier than having us get you out of it. Once the leave is used, it's gone for good. So if you've got people that have already used their COVID leave, they don't get recharged with it every year. It's 80 hours from the day the public health emergencies went into place, and they don't get more as this thing keeps going along. Paid sick leave and PHE leave do not get paid out when somebody leaves. That's one of the reasons that folks are comfortable giving that 48 hours of paid sick leave on the front end and just saying, I don't want to mess with accruing this. You got 48 hours. If somebody leaves 3 months in and they've got that 48 hours still sitting there, it's not like vacation. You don't have to pay it out to them. So you're not putting yourself in a deficit position if somebody leaves by having given them the full 48 to use whenever they needed it. You're not in compliance with this statute and the rules around it if you don't have a written policy. You have to tell the employees how this works, and it has to be in writing, and the best practice is to have them sign off on it like any other important employment policy and keep a copy of it. All right, same goes for required posters. Please make sure that you have the posters up that the Department of Labor and Employment requires you to have up and the Equal Employment Opportunity Commission requires you to have up. They're getting to be a lot now. Go to Home Depot or wherever you go and get like the office supply store and get one of those big bulletin boards, or maybe 2 of them and several boxes of thumbtacks. Go on the CDLE website, the Department of Labor and Employment website. Cindy's got the link in the chat for you. You can go to one place on the CDLA website and get all the posters that you're supposed to have. I know the Livestock Association also does that for you and makes those posters available to you. However you get a hold of them, get them and put them up, because if they come out to inspect, especially if you've got H2A folks, we think they're going to start coming out to inspect more often than they ever have in the past. They will look to see if you have the posters up, and you get dinged if you don't. Colorado Family Leave Program. Now, separate and apart from 48 hours a year under Healthy Families and Workplaces Act, we've got a new paid paid leave program called Colorado Family. What that does is provide 12 weeks of paid leave to someone who is experiencing a serious health condition, who has to take care of a member of their family who has a serious health condition, or who's had a new child or adopted a new child. Those are the reasons that you get to use family. Family doesn't come directly out of your pocket. Think of it as operating like unemployment insurance benefits. All employers and with family employees pay into a big pool that then pays the benefit of up to 12 weeks of paid leave to employees when they need it. They get about 66% of their normal pay from the family program when they go out on family leave. What you need to know is your contribution is 0.9. The total contribution is 0.9% of the employee's compensation, the amount that they're paid. It's split between the employer and the employee, so 0.45% each. And if you have less than 10 employees, so 1 through 9, you don't have to make the employer contribution. You can, but you don't have to. You do still have to deduct the employee contribution, even if you just have 1 employee, okay? Up to 10, it's 1 through 9, you don't have to make your side of the contribution, but you do have to make the employee contribution. The contributions have already started. They started the 1st of January 2023, but you're not in trouble yet because the employer contribution and the employee deductions, they go in quarterly, just like your payroll taxes. All right, so the first time you're actually going to pay into this thing is in April. The benefits don't start until 2024. They're going to build up the money And then assuming everything works right, and who knows whether that's going to happen, they're going to start paying benefits to employees in January of 2024. Please make sure that you register with the Department of Labor and Employment. It's easy to do. The link for the family registration is in your chat materials. Even if you don't have to put your side in because you're too small, you still have to register because the government has to know where they're going to put your employee contributions that you're sending in, okay? Colorado Department of Labor and Employment, you look at the family drop down, you go to employers, and there's a spot there that gives you some tools, some guides, and a toolkit so that you get this done right. If you haven't registered, please go home and do it tonight. This is something you need to get done. Okay, family leave does not replace Healthy Families and Workplaces Act leave. I've had this question a bunch. They're both going to go side by side. We don't know exactly how they're going to integrate. We're going to get some more rules on this, but just for now, keep in mind the 48 hours accrues or you're front loaded, that's paid sick leave. There's still public health emergency leave if somebody gets COVID or has a family member who gets COVID. That's the 80 hours, and then this is on top. Family is on top of that, and once it goes into place, it will be an extra type of leave. Vacation time can't be forfeited. If you have a PTO program or a vacation program where you give folks leave that they can use for any reason they want, it's not paid sick time, it's leave for any reason they want, you can't take it back from them once you give it to them. It has to be paid out when they leave, and you can't have a use it or lose it vacation program. We used to could do that in Colorado. We can't do it anymore. If it shows up on their paycheck stub, and if you have a vacation program, it should, that they have 10 hours of vacation time or 10 hours of paid time off, that's theirs now. And you can't rein it back in from them. All right, labor organizing, I'll finish with this. As I said, you're now subject to the Colorado Labor Peace Act. You're the only employer type that has to have only one employee in order to be subject to collective bargaining and organizing. We have not seen any organizing by unions yet, but if you see stuff like this, Justice for Farm Workers or the United Food and Commercial Workers, if you see pamphlets or sheets that have been handed out, or you hear people talking about this stuff, get help, get help. Likely as not, you may be the first farm or ranch or other agricultural employer to be organized by a union pushing for a collective bargaining unit. And there's some stuff you're going to have to learn about that you don't know. I guarantee you, you don't know. You can call us. There's a whole bunch of good labor lawyers around Denver. They can help you, no doubt about it. But please don't try this by yourself. If you see anything about labor organizing on your farm or ranch, call somebody for help. Because, and also please let Chad at Farm Bureau or let Zach know at the Livestock Association, because we're trying to keep up with this issue and whether it's actually going to occur in Colorado now that you are exposed to it. With that, I thank you for being so kind as to allow me to yammer on at you for well beyond the line that I usually draw, which is if you have to sit and listen to a lawyer yell at you for more than 60 minutes without a break, it's a clear violation of the 8th Amendment to the United States Constitution. That's the one that prohibits cruel and unusual punishment. It has been my pleasure and my privilege to talk to you today. Don't be a stranger if you need help. And thank you, Chad, and thank you, Zach, and thank you, Brian, for making it possible for us to do this. You all stay safe and take good care.
Thank you, Kevin. Thank you, everybody who made everything possible today. Please reach out to your prospective organizations if you have additional questions or concerns. And as always, you know, Range Law is available for hire if you need to, and I would definitely advise giving them a call if you need specific legal advice in this space. Thank you again to Brian Schiller and Flood & Peterson as our sponsor today, and thank you everyone else who has participated. Please have a great week and a safe rest of your weekend.